For the most part, child support is a pretty simple formula. There are child support guidelines where you put in one parent's income, the other parent's income, the percentage of time each party has parenting the child, meaning their access time. You may put in other important things such as the cost of the child's health insurance, the cost of any extraordinary medical expenses that are known and ongoing, the cost of any work-related daycare, and sometimes even travel costs if both parties live far enough apart that travel is required for access. This is going to spit out a number. And for the most part, that's child support. But as with everything, it depends. There are occasions where child support can be deviated up or down. One such occasion is if there's a prior child support order. The payor is already paying child support. That might be factored in. Another deviation might be if there are extraordinary circumstances, and they have to be extraordinary, and they have to be in the best interest of the child, where child support should be deviated up or down. The court has the opportunity to do that. And finally, there are the very wealthy parents. At a certain point, wealth becomes such that the child support guidelines may not make sense anymore. And at that point, the court is going to look at the child's needs and both parents' abilities to pay, and there's another calculation that the court's going to do. If someone is not paying child support, there is a lot that the recipient parent can do on behalf of their child to make sure that child support gets paid. First, you definitely want to talk to the Office of Child Support Enforcement and see if there's anything that they can do because they're going to be your lowest cost option. Unfortunately, your lowest cost option, even with all the best intentions of the world, does move rather slowly. The reason is there's a lot of people in the system and there are a lot of cases to get to. If you need something fast, you need to talk to a private attorney. What a private attorney can do is file a motion for contempt and to enforce, arguing that the other parent should be forced to pay. I have been involved in child support cases where a motion for contempt and to enforce has been filed, and it has found that the payor had the ability to pay the whole time, and the court has even threatened jail time. Now, that is the extreme. That parent had the ability to pay and was choosing not to. But what happens if perhaps the parent doesn't have all the back child support sitting in a bank account somewhere? Well, there are options. Number one, you can seize what is in that bank account once you get the child support reduced to judgment. You also can seize tax returns, any money that was going to be coming from a tax return. Also, a payor's driver's license or even passport could potentially be not renewed if their child support is not paid. These are just some of the options. You can also garnish wages. Potentially, if it's reduced to judgment, you could even seize a car or seize other property. You could put lien against their home. There's a lot of really aggressive options that you can take to make sure that your child gets the support that they are owed and that they deserve. It's not easy, and it's always better if you hire a lawyer. There are times where child support may need to be modified. Perhaps you have 3 children and the oldest one aged out, so child support needs to be modified. Maybe you lost your job, or maybe you got a significantly higher paying job, or your co-parent got a significantly higher paying job. Or maybe something tragic happened. Maybe you're really sick and unable to work for a period of time. There are a lot of different things that can cause child support to be modified, but at the end of the day, what you got to look at is a material change in circumstances. Is there a significant need change? Is there a significant change in the needs of your child for child support? And is there a significant change in either parent's ability to pay, positive or negative? And that's what the court's going to look at. In general, child support is only terminated in 3 circumstances. Number 1, there's a step-parent adoption and you are no longer the parent of that child. Number 2, the child is emancipated. This means they age out of the child support system. And number 3, if the child emancipates themselves. If they get a declaration that they are emancipated and now they are being treated legally like an adult, you no longer have to pay child support. Child support issues can be complicated, but legal representation for them doesn't have to be. As part of your new beginning, you want to make sure that your child is taken care of. And that's true whether you're the payor or the payee. At Z Family Law, we don't write endings, we create new beginnings. And we would help you and your children create your new beginning. Call now for more information or click below.